My name is Netta Sagafi. I am Vice Chair of BHBA's litigation section. I am delighted to introduce our speakers, Christopher Frost and Chanell Botshekan. Christopher Frost is the founding and name partner of Frost LLP, a bicoastal litigation firm he built as an alternative to big law. Over a 25-year career, he has represented media companies, musicians, athletes, executives, and tech startups in complex business disputes spanning antitrust, intellectual property, employment, and partnership matters. Variety has named him one of Hollywood's top entertainment attorneys. He clerked for the Supreme Court of Texas and has appeared before the California Court of Appeal and the Ninth Circuit. Chanell Botshekan is an associate at Frost LLP, where she handles complex commercial litigation, including class actions, consumer disputes, product liability, and regulatory matters. She previously practiced at one of the world's largest full-service firms, focusing on high-stakes class actions and regulatory matters involving consumer products. She brings a distinctive ability to translate scientific and technical concepts into legal strategy, and she earned her JD from the University of Southern California Gould School of Law, where she was a member of the Hale Moot Court Honors Program. So I'm delighted that both of you are here with us, and now let's go ahead and get started.
Thank you for the kind introduction, and all of you who are here, thank you for joining us today. We at Frost LLP every month publish a column in the Daily Journal called Frost Bites. And when Chanell approached me about an idea she had for an article a couple of months ago, it was on this topic of oral advocacy and oral argument. And one of the things that it really resonated to me was because one of the things that we're seeing in the ups and downs and the trends, good and bad, that we're seeing in the legal industry, one of the things I think that we are suffering is a loss of an opportunity to really engage in oral advocacy. When we were children thinking about what it would be like to be a lawyer, that's what you think about. You think about being in front of a jury, you think about arguing. And to some extent, I think we've lost that art. I think there are a few reasons for that. One of which is the tendency of courts, especially federal courts now, to take matters under submission without oral argument. Another is the tendency, in a lot of larger cases where the stakes are higher, to sort of defer to the written work and hope that that carries the day. And we really lose the confidence and the opportunity to engage in what is probably the most influential way of influencing, impacting the effect that our arguments can have in whatever context that we're raising them. You even look at law schools, and the clinical part of law schools and legal writing is mandatory in most schools. Oral advocacy is not. And I think that is a reflection, again, of the trends that we're seeing. So when Chanell came to me and said she had this idea to discuss oral advocacy and oral argument and how do we rescue it, if you will, I thought it was a great idea. So you're going to hear more from Chanell than me today, but we hope you enjoy the presentation and take something confident and caring away from it.
Thank you, Chris. So yeah, touching on quickly my feeling about this, it really stemmed from sitting down. I'm in my mid-level years. I really wanted to figure out where I wanted to take my legal career, and I realized that I was really underdeveloped in oral advocacy experience, and I didn't know what to do. So I asked friends and colleagues with a similar experience level, and they also had the same feeling. And so I really wanted to think critically about the ways that I could improve given the environment we're in. And so if you remember anything from this presentation, I hope these three things stay with you. Next slide. The first is that oral advocacy is a skill. It is not a talent. It's not, conducive to personalities. It's something that you build. It's not something you either have or you don't. I was very guilty of that framing. When I saw skilled oral advocates, I always thought they were just so talented. And while they may have a talent for oration, they likely just accumulated practice. Next slide. Because it's a skill, skills do require practice. So if you think about most skilled oral advocates that you know, they're likely attorneys who have had the most reps, most consistently in the most diverse situations over the longest period of time. And the ability to think on your feet and persuade a live audience are capabilities built incrementally through repetition. They're not, once again, they're not just something you have or you don't. Next slide. And this is key to me, and particularly if you're a developing attorney who's trying to get comfortable with oral advocacy, practice doesn't make perfect, effective practice does. You cannot develop oral advocacy skills by relying on tools that aren't actually challenging those skills. So, effective practice should include and demand spontaneous critical thinking, adaptation, challenging your judgment. If you're relying on memorizing written materials, reciting talking points, or even just reading long outlines, you're not actually challenging yourself. And so those skills won't actually be developed. Next slide. So I do just want to mention briefly, just to, give you a defined term of what we mean when we say oral advocacy for the purpose of this presentation. It's any event in which you must speak to defend or advance your client's interests. So any context in which you're trying to persuade another person of your position. Our discussion today is not limited to courtroom argument. So depositions, negotiations, mediations, deal discussions, literally any environment where you're trying to persuade another person of your position live, it counts. And this has obviously always been essential to legal practice. And the landscape of the legal industry for developing attorneys used to naturally provide sort of low stakes opportunities for attorneys to get exposure into oral advocacy and building those skills over time. And that was pretty important because legal education, at least in the last sort of 25 years or so, hasn't really done a thorough job clinically of training law students. Next slide. So clinically speaking, most JD programs are built around research, writing, and bar preparation. Oral advocacy is not typically a core requirement in law school curricula. There are optional programs, like mentioned previously. I participated in moot court. I had friends who participated in mock trial programs at USC where I went, but it's not really reliable. First of all, those programs are optional, and they're typically done one time in a law student's career. So for moot court, for example, available to second years for you to participate. You get to participate in the program one time, and then you move on for the next crop of second years to participate. So this results in most attorneys not having any formal oral advocacy training whatsoever by the time they graduate. And so they enter practice with the assumption and the hope that, it'll develop naturally over time. Eventually, they'll just, wake up one day and realize that they have this experience and these skills are developing. But in today's landscape, it's happening less and less. Next slide. So there are two major shifts that are happening together that's really making this difficult for developing attorneys. The first is the increase in billing rates, and subsequently the increase in cost-conscious clients. Now, obviously, this isn't new, right? Clients didn't just start checking the bills in the last 5 years, but it's intensified given how high billable rates have gotten. And all while that's happening, we have an increase in court efficiency, right? So courts are issuing tentative rulings, parties are submitting, and it typically happens with lower stakes hearings, which were the opportunities for juniors to be able to get comfortable before a judge, get comfortable arguing in a low stakes environment where, if an attorney makes a mistake or is unfamiliar, they have time to build up that experience without fundamentally harming their client's case. And so the result is just sort of a whirlwind of conditions. The new attorneys are graduating law school, entering into practice, and just, years into their career realizing that they really don't have any meaningful oral advocacy experience, but are really great writers. Next slide.
Chanel, one of the
Mhm.
things I think that's fascinating to see is fascinating in one sense, and I think troubling in another sense is on the first point you made with respect to the higher billing rates. I think, this what we're seeing, one of the trends we're seeing in the industry right now is as we're paying more junior lawyers more money, there's an inverse proportion between that many times and the amount of credible experience we're allowing them to have or able to give them. And I think one of the things that's driving that is, as we increase salaries for our junior lawyers, you have to increase compensation across the board to avoid salary compression. And what that does in a firm environment to maintain profits per partner is that's oftentimes increasing the floor of the type of case that that firm can take. And as you increase the type of floor and increase the value of those cases, you end up a lot of times with firms that are unable or unwilling to give junior attorneys more meaningful experience because if a client is paying that much or the case is worth that much, then clients get concerned about that, and so junior attorneys, for that reason, start getting relegated to more less front-facing roles. And so you're ending up with this sort of inverse proportionality where what we're paying people is not commensurate with the opportunities we're able to allow them to have.
Perfect. And it's a perfect segue into the next slide, literally. The economics of how we staff our matters. Senior attorneys have to defend their decisions, especially with clients looking at the bills closely, looking at staff closely, seeing who on the team is billing how much amount of time and working on what. And as Chris just stated, it can become really difficult to justify staffing a junior attorney on a matter and having them handle certain high stakes events, given the amount of money the clients are paying. And it's not just the hourly rates. I mean, litigation in general is extremely expensive, has gotten more expensive over time. I mean, depositions can run a client between $8,000 to $10,000 a pop. And so when you factor in how much money a client is going to have to pay to depose a party, they're more likely to be choosy about who they want to depose, and it's limited to parties, the most important depositions. And so, as opposed to having, party depositions and then also third party depositions that are maybe smaller in scale and less critical, where juniors maybe could take, a shot at first chairing a deposition of a third party, and getting comfortable. Now you only have, a party depositions available. And the client's not going to want a party deposition that could be crucial to their case to be used as a training ground for a developing attorney to get comfortable with depositions. And the same logic applies across sort of every significant oral advocacy event. And obviously, the instinct to staff carefully is understandable. And, our job is to serve the client's interests. And so that's first and foremost. Not to mention, senior attorneys have their own pressures, right? They have to maintain that client relationship, ensure that they give the client, good work. But the unintended consequence is significant, right? Because if juniors are developing without all of those low stakes opportunities, then where do they develop the skills? And as they age into taking more ownership at a strategic level, it should follow that they take leadership in running those oral advocacy events, right? Taking first party depositions. But if they've never really had the opportunity to take depositions, what do we do? Next slide. Similarly, this is happening, as Chris mentioned, in court generally. There's just fewer hearings on calendar being heard because tentative rulings have become sort of a regular occurrence now. And even when a tentative is not particularly favorable, but maybe not worth fighting, parties submit rather than potentially sending a junior attorney to go and argue. And the hearings that do go forward typically involve the higher stakes hearings. Once again, unlikely that you would send a junior to maybe a dispositive motion hearing. But if if your party is submitting on discovery motion hearings and not appearing to argument, well, the opportunity for those juniors to get any sort of courtroom argument experience is kind of, it's diminished by that point. Not to mention, there are some other things, right? So California is really in favor of the use of arbitration clauses, which means fewer trials and cases go through the court system at all. So just generally speaking, we're just seeing fewer opportunities for juniors to get exposure. Next slide. And so with that, now I've started to notice, and I've sort of asked around to friends from law school who are participating in or practicing in different states and different environments, are also noticing at their respective workplaces this in-house specialist problem that's starting to arise, where fewer attorneys are being trained consistently on how to argue. And so there are attorneys in, a firm, for example, who do know. And so there's just a small group that just gets sent around to argue on matters that they're not staffed on. And this likely happens organically, right? If you're an attorney who knows you're not particularly comfortable with oral advocacy, and Jane across the hall has handled multiple trials, is extremely skilled and experienced, you may just ask her to help join you on this matter and assist with oral advocacy. But one, you're taking your own opportunity away to get another repetition of an oral advocacy event in. But also, the more people in that firm rely on Jane to handle all of their oral advocacy matters, now the firm is fundamentally reliant on her to handle the oral advocacy experience. And if she retires, if she decides to leave, what happens to the firm? Everyone needs to sort of step up and handle their matters. And if you are sort of delaying or deferring your handling of your own oral advocacy matters for the purpose of, say, pursuing a better result that you hope for the client, you're only delaying the inevitable, which is still you have to handle your own matters eventually. Next slide, sorry. And so when you don't have experience, you default to coping mechanisms. For us, most lawyers who have formal training, you are good writers. From the beginning of law school, even joining firms, most firms have writing programs that junior attorneys have to go through. And so you start to default to written materials as a way to get through oral advocacy events. So this can be in the manner of extensive outlines that anticipate every counter argument, maybe even pre-written answers or exhaustive scripts. Deposition outlines can just be, lists of questions that you follow verbatim. I know I'm guilty of this. I have written deposition outlines that exceed, 50, 60 pages and watched them followed verbatim beginning to end. And so obviously, the script promises security and it minimizes surprise, and that's comfortable. But first of all, when you walk into a room with a 20-page outline that you intend on reading, your goal shifts from listening and responding to just delivering a plan as as you've prepared. And so the script really holds you back from developing oral advocacy skills in the first place because you know how to write, you've received that training, and you know how to read. Nothing is being challenged, as opposed to if you walked into the room, really required yourself to try and challenge yourself, exercise judgment, really be present, be flexible, focus on understanding the law and the record rather than memorizing talking points. That's how you actually train up your oral advocacy skills. Next slide. And so this just becomes a cycle, right? Just lots of things happening all at once that can compound on each other and make it more and more difficult for juniors to get exposure to oral advocacy, primarily because the firm is more careful about how they staff juniors. So then they get less practice, which means they don't develop as many skills as early as they potentially should, which then typically means that the folks staffing who are aware that maybe they don't have a lot of oral advocacy experience are less likely to put them on a matter that would require them to get exposed to it. And it just sort of goes around and around. Next slide. And so I do just want to flag as well for everyone that skills to be a good writer and the skills required to be a good oral advocate really don't overlap that much. So writing really rewards planned precision, thoroughness, and completeness, how good you are at anticipating oral arguments and potentially counteracting them immediately. Also really rewards how good you are at revising your work, sitting with your work, and refining any errors before the audience ever sees it. And so obviously, really key skills to have, but this is only half of the skill set any good attorney should have. Next slide. We also need these skills, though they're harder to get and never really formally trained, but we need to understand how to really expand and maximize our working memory, be active listeners, focus on having good perception of what's happening in the room, being responsive to what's happening in the room, emotionally regulating under pressure, and not only having good judgment, but also trusting our judgment. Next slide. So I do just want to mention working memory. It is really crucial for good oral advocates. Most skilled oral advocates have really robust working memories, even if they don't know the term or whether they can identify it specifically. But working memory is the cognitive system in your brain that allows you to temporarily hold information, manipulate that information while you're completing a series of complex tasks. So it's distinct from long-term memory, which is just memory information you've held for long periods of time that's available for recall. And it's also distinct from short-term memory, which is just having information in your brain for a short period of time so that you can recall it, typically for a particular purpose, and then it leaves your memory. Working memory kind of bridges the two. It allows you to hold information in your memory, typically for longer than your short-term memory would allow, but also allows you to manipulate that information. And it also allows you to hold different streams of information and allow them to inform each other in your decision making. So on the next slide, I'll show you how that can be tied to oral advocacy specifically. So in oral advocacy, your working memory is managing multiple streams of information. So first is just the knowledge you know about your case. So your arguments, the record, the applicable law that applies to your position. Then you have whatever is being said to you. So judges speaking to you, opposing party, opposing counsel, and how you should respond discreetly to that stimulus. Then you have the objection or the objectives for the interaction. So if you're before a judge, maybe the key arguments you want to make sure the judge knows, or if you are before a deponent, the admissions you need to get out of them. Then you also have the signals that you're getting in the room. So the nonverbal cues, a body language, tone of voice, everything that's letting you know what the other party in the room is thinking, feeling, and how you should respond. And so you're not just remembering your position, you're not just remembering, key parts of the record or applicable law, but you're also holding all of this extra information and using it to your advantage to be as effective in the room as possible.
Chanell, it's fascinating, and when you talk about this, the idea of working memory and how that interacts and correlates with mid to long-term memory as well, because when we're dealing in cases that are now, especially in state court, going 3, 4, 5 years or with stipulations longer, you end up in a position where when you're in these arguments and you're having to adapt and work the room, if you will, you also have to maintain that longer term memory, which is your memory of all the facts of the file, and how those are going to interplay. Because a lot of times, even when we show up to a case management conference, sometimes it will be just the judge will make it perfunctory and push it through, and other times the judge will be inquisitive and want to know about the case generally. And so, but especially when we get into oral argument on the issues that are more substantive, a lot of times issues may come up that the judge may raise that have to do with your historical knowledge of the file and not necessarily what's on paper. So we get this intriguing interaction between the necessity to exercise your working muscle memory, if you will, and your long-term memory as well.
And it is something that you notice, having been a junior very recently, I've noticed how skilled more senior attorneys are at just remembering everything that happens to come up in a hearing. They just have so much information floating around in their head. But the interesting thing is that working memory is also kind of like a muscle. So it can be expanded the more you use it and the more you challenge it. So it's the reason why sometimes as a younger attorney, I've struggled to remember, 3 or 4 pieces of information at a time to keep a hearing moving forward. But I'll see, I've been in hearings or in depositions with Chris and watched him remember things that came up 30, 45 minutes ago and remember not only exactly what was said, but know the exact time to bring it up. And it's really a tool of experience. The more you challenge your memory, the better it will get, and the more you can effectively use it to your advantage. Next slide. This is so important. I have not heard nearly enough discussion about this in law school and also training for juniors. Emotional regulation is key, especially in oral advocacy events. First of all, you just have the nerves going into the event. Now you have maybe frustration if you're being interrupted and you're not prepared to be interrupted. Maybe the judge is sort of waving off an argument you think is really compelling, and so maybe that makes you a little angry. Maybe opposing counsel starts raising their voice. Maybe they're also unregulated, and that gets you unregulated. And so having these feelings, these reactions to the things that are happening to you in the room, super normal, but you need to maintain your composure. And once again, it's really difficult to teach someone this. You just have to be put in situations that continuously stimulate your emotional response, and you over time learn how to better and more effectively manage your emotional response to ensure that you're still performing effectively.
And there's sort of two parts of that, right? One is you have to maintain your composure, and on the outward facing, you have to become unflappable, right? But you also have to be able to get to the point where even internally you're not allowing sort of the noise around you to influence where you find your balance in terms of these continuing with your whatever oral advocacy context you're in. Because even if you don't show outwardly that even if you're showing outwardly that you're unflappable, if you're allowing it to get to you internally, you're allowing your opposing counsel to dictate, how well you're going to perform, or the judge's critique or whatever it may be. That is the unnerving event. You've got to maintain that internally and keep your focus and remember that you are unflappable and you have to remain unflappable.
Absolutely. Next slide. This is also really important. Another thing that really can help you and compound your ability to be effective on a matter in the long term, is reading the room, being able to observe contextual clues that are happening. So, for example, from the bench, it can be very easy to tell. So, if a judge is leaning in, maintaining eye contact, asking questions, seems very engaged versus maybe, leaning back, flipping through papers, maybe you'll hear a heavy sigh or two. that gives you information on not only how the judge is feeling about your argument or maybe even opposing counsel's argument, but also how you should change what you're doing to better suit the interests of the judge. So if you notice you've been talking for a while, judge started out very leaned in, very engaged, and has now started to lean back, and look around. Maybe that means you need to hurry up that point. Maybe that means you need to speak more efficiently, because perhaps signaling that you're losing the judge. Similarly, in a deposition, you can tell kind of what's going on. So if a witness who started out really confident becomes hesitant to answer around a particular topic or issue, maybe that means that they're uncomfortable talking about that. Maybe you need to think about, given the facts of the matter, why that is. If opposing counsel was not super engaged, but starts maybe writing lots of notes, maybe they start, rapidly and frequently objecting when you start touching on a particular topic, maybe that's worth probing into more. Try to figure out why they're so bothered when you start touching on that topic. Even in negotiations, if opposing party is really pushing back on certain terms of a deal, that tells you information. If opposing party was really concrete and substantive in their discussions about certain terms, but now is suddenly hesitant to give you any sort of substantive response, maybe that signals they don't have authority to agree to certain types of terms. And maybe you need to consider that. Maybe you need to inquire about that, right? You get all of this information that not only helps you in the room that day, but as you move forward in the matter, either litigating that matter or, working on a deal, whatever the context is. So it's really important that you think about those things and you don't just leave that information sitting in the room, walking away from the event without also noting how the judge felt, how the opposing counsel felt, how what the opposing party said. All really key information.
Chanel, on the issue of the deposition, one of the things I think that is easy to forget is even from the defense side of defending the deposition, that's still a position of advocacy, and you are advocating when you're making objections, whether you realize it or not. And we can say all we want to that objections are just for the record, and technically that is true. But we are taking a position with opposing counsel every time we're making an objection, and we have to be careful in the way that we do that, that we're not overplaying our hand. For instance, one of the things that I see commonly is when I'm taking a deposition, I know I'm pushing the right buttons and I'm getting into the tender areas because of how loud and vociferous my opposing counsel becomes with not only the objections they make and the number of objections they make, but the manner in which they make them. They get louder, they get faster, they get angry. And those are tells that we need to be careful about. So as much about oral advocacy in that conversation and in that context and others is as much about what we're not saying as to how we are. And to be effective advocates, a lot of times it's best to be careful in the manner in which we are conveying the information, that we're not saying too much or saying something that we're unwittingly not meaning to.
Mm. Next slide. It's really important to know essentially when to hold and when to fold. So the art of the pivot is the ability to abandon a planned line of argument in favor of a stronger one that emerges in real time. This can be made difficult if you are someone who is prone to reading scripts or feeling like you really need to heavily plan an event rather than being flexible and being adaptable in the room. So for example, this is the easiest thing in the world to do. And if you're a developing attorney who maybe is going to start attending and arguing in hearings, very, very important, easiest thing in the world to implement. If the judge signals they agree with your position at any given point in the middle of your argument, stop talking. Do not press it any further. Not only are you wasting time, but you are creating more opportunities for you to say the wrong thing and to lose the judge. So if they say they agree with you, just stop. take that win, they agree with you, move forward. Similarly, if you're in a deposition or you're questioning a witness and you really thought this was going to get you a certain type of admission and it's just not landing, either the witness is being evasive or they do give you an admission, but it's not as, groundbreaking as you thought, consider whether it's time to move on. If it's a really important topic, maybe you don't abandon it altogether. Maybe stop for now and bring it up in 2 hours. But just no, don't waste time trying to pursue a certain topic or a certain, type of argument if it's not landing. Similarly, if witness gives an answer that implicates information you didn't know, so implicates maybe a third party or another issue, make a mental note of it and go back to it. Don't just abandon that altogether or ignore it because you have, a long outline in your hand that doesn't mention that third party or that topic. Sometimes you need to go off script. And in those environments, you potentially are leaving a massive discovery or admission on the table if you don't pursue it. Similarly, if the court raises a concern, earlier than anticipated, this goes back to the first point. You follow the court's direction. So if the court wants to talk about, a certain type of issue, even though it technically should come up later in an analysis, you just go directly to where the court wants to go. And sometimes it's not when to stop. Sometimes you have to think about when you need to keep going. If you're in a deposition and a witness is sort of giving you an answer that contradicts something they said prior, even if you're technically at the end of your line of questioning, perhaps that means you need to continue questioning. Maybe you need to consider where this contradiction is coming from. Maybe you need to ask them. Maybe you need to go back to the questions you were asking prior that they're contradicting now. Don't just stop because you're at the end of your outline. Sometimes you need to be flexible. And so once again, you could be leaving a massive, a massive benefit to you and your client on the table. You have a witness who's now contradicted themselves on the record. Go explore that. Next slide. So when we don't have opportunities to get comfortable with oral advocacy, we start to develop bad habits as a coping mechanism. We just walked through the skills that oral advocacy really demands. And when those skills are underdeveloped, we do what we can to make oral advocacy events, one, feel more comfortable, but also sort of ensure that we're going to have a baseline level of performance because we don't trust those sort of underdeveloped skills that we have. And these bad habits can actually form a chain that make it much harder to develop oral advocacy skills down the line. Next slide. So because argument feels rare and high stakes, preparation defaults to what we all know best, which is writing. Next slide. And so because your preparation is defaulted to writing, your outlines, your scripts, they get longer, they get more detailed, more pages, more anticipated questions, they're more verbose. Maybe you even go so far as to pre-writing answers. Next slide. And so because the scripts get longer, the goal for you in the room shifts. So where you should be listening actively and trying to be effective and efficient, and responding directly to the stimulus in the room, you're now thinking about just delivering the next point. Next slide. And so because the goal is delivering the next point, now you're not listening at all. Now you're not even present. You're really focused on your written materials and you're focused on executing the plan as opposed to having a conversation. Next slide. And when you stop listening, you miss everything. All of those key pieces of information, everything nonverbal the judge is telling you. You may even miss something verbal the judge is telling you. If you're focused on giving a really long answer to a question about an analysis that the judge only asked a very particular key point, you're missing where the judge is focused on. Next slide. So I just want everyone to think about this hypothetical. I have certainly been in this situation before. I'm sure most, senior attorneys who've been practicing for a long time can remember a time like this. So I want you to imagine you're in a motion hearing. You are going to be arguing about a three-pronged issue. You are prepared thoroughly. You have a detailed outline. You've anticipated every argument. You've also interwoven key parts of the record to associate with the parts of the law that you'll be arguing. And so you get into the hearing, you make your appearance, you start arguing at prong one. The judge almost immediately interrupts you and asks a very specific question about prong three. So you're prepared to discuss prong three, but you're currently reading from page 2 of an outline, and prong 3 is on page 9 of that outline. So now you're trying to do two things at once. So you're trying to listen to the judge, but you're also flipping to find where prong 3 is. And unfortunately, this outline is so long that it's requiring you to read the outline to find where you are. It's not short enough where you can skim or glance at the outline to tell where the material is. So by the time you're done flipping, you find page 9, you find prong 3, you realize the judge is not talking anymore, which means you completely missed the second part of that question. So now you're in a situation where judge has asked a question. Are you going to ask for them to repeat the question? You probably should. But you're still on, you're on page 9 of this outline. You still need to read through the outline to find your answer to the judge's question. And so in this situation, you're not unprepared at all. You're extremely prepared. You know the record, you know the law, and you put a lot of hours into putting these written materials together. But instead of just trusting that you know the answer, that you can respond, you feel like you need to, you read this outline that you've written. And so a lot of oral advocacy is trusting your ability to have a command of the law and the record and trusting your ability to be flexible. But if you don't trust yourself, you're going to default to just reading. One, it doesn't really give you a better performance typically. But two, you're also taking an opportunity for you to challenge your oral advocacy skills away from yourself. And, this hearing somewhat doesn't count because all you did was stand in court and read. Next slide. Now, if you take the same dynamic in a deposition, so let's say you are 2 hours into a party deposition, you have a 60-page outline, it's built entirely around opposing parties' written discovery responses. You're going through question by question, verbatim. Everything has gone according to plan. So, about 2 hours in, you ask the question, deponent gives you a completely unexpected answer. Something that hasn't come up in written discovery at all, something you've never heard of. You have absolutely nothing planned or prepared for this topic. You look across the table, opposing counsel heard the same answer you did. And now you see lots of note writing back and forth. And your instinct should be to go off script completely and to ask more questions about this new, thing that the deponent has brought up. But because you've been reading this script for 2 hours, it's unlikely that in the moment you'll actually do that. It's likely that you will maybe make a note of what that is, but you'll continue verbatim with your outline. Typically, humans across all industries, across all circumstances, when we feel pressure or stress, we default to our habits. And so if you build the habit of having a long written material in your hand that you read, if you feel sort of stress in a situation, a deponent has brought something up, you start to get a little stressed out because you don't have anything planned, you will default to your habits 9 times out of 10. And if you've built a habit of reading an outline, there goes that opportunity to inquire from the deponent what this issue is, how it's relevant. could potentially be massive for your matter, for your client, but you have to trust yourself to pivot. You have to trust yourself off script. And those things can only be built if you rely less and less on written materials. Next slide.
One of the things, Chanel, that I think is important, I think that's exactly right. One of the things I think is important to consider is there's nothing wrong with a long and detailed outline. There's nothing wrong with writing down all of the points you think you need to make. But especially with like a court oral argument or the like, use that as an opportunity to develop some muscle memory, actually going through the process of writing down the questions and writing down your thoughts, even verbatim, forces you to learn the issue better and to learn the material better. But take that next step and take that before you go into your oral argument and synthesize that down to a list of bullet points that are the most important keys you want to hit so you make sure you don't miss anything, but you're forcing yourself to become less reliant on the outline itself and more on your memory with the sort of teasers there to remind you to make sure you pick up all the points.
Absolutely. The goal is not to prepare less. The goal is not to, not draft an outline, not go through all of the points that you'll need to consider before argument. The goal is just to prepare differently. So you shouldn't spend all of your preparatory time on building written materials. Some of that time should be focused on really understanding the legal issues. So perhaps not memorizing a perfect synthesis of an analysis. Perhaps it means, diving deep into your understanding of the issues so that if the judge asks a question that cannot be cleanly answered by sort of, a perfect synthesis of an argument, you have the flexibility to be able to answer their specific question. You don't want your preparation to fall apart the minute the room goes off script or the minute something happens in the room that you didn't anticipate. You want both, having a structured understanding of what's going to happen in the room, but also such a deep understanding that you're able to be flexible and adaptable. Generally speaking, I would advise for hearings and even, as you get better with depositions as well, you want your written materials to be purposeful. You don't want to include information that you're just hoping will provide a complete answer, but doesn't actually provide substance to the listener. You want reminders of key points to hit. You don't want to be forced to read from your document. And so you want to prepare thoroughly, definitely, but you don't want all of that time being focused on writing an outline. Spend some time rehearsing how you want to frame certain arguments or rehearsing how you're going to respond to questions about the weak points of your arguments. You want to hear how you sound. You want to hear how different framing sounds. And you want to really flex your understanding of the issues and of the facts so that if something random happens in the room you didn't anticipate, you can still draw from your understanding to be effective, as opposed to having awesome prepped, written materials that essentially become useless the minute the judge asks you something that, can't be answered by something you've written down. Next slide. I also just want to note, as attorneys who haven't had that much oral advocacy experience develop, they're also charged with, being involved in strategic decisions. And I just want to caution you that you shouldn't necessarily be allowing your discomfort with oral advocacy to drive your strategic decisions. So, for example, if you receive an unfavorable tentative and you genuinely believe that your arguments are compelling, that they're backed by really good case law, and you really think that the judge should reconsider, go argue. Don't just submit to the tentative because it feels like a loss or because you're unsure of your ability to persuade the judge. Go and argue, first of all, because that tool is massively important for your client and their interests as well. You don't want to just take away that tool from your client because you're uncomfortable, but also it's an opportunity to go build those skills. You don't want to just leave that hearing on the table when that could have been a session of practice for you to develop your skills. Similarly, advising against trial because you're uncomfortable with trial. Now, I think there's an ethical gray area here, right? Because on the one hand, if your client is best served by going to trial, technically, as their legal advocate, it is your job to pursue the best interests of their case. However, we also do owe a duty of competence to our clients. And so, you do need to be careful about ensuring that, any environment you walk into, you do so competently. But at the end of the day, you don't want to be advising your client on strategic pathways that aren't the best for them because you're uncomfortable with oral advocacy. You want to make sure that not only are you pursuing opportunities that are best for their case, but also you're pursuing opportunities to create environments and exposures to oral advocacy and building those skills.
Chanel, I think one of the best, worst, if you will, areas where this tends to present itself is when we're getting ready for trial. And people start getting nervous about the idea of going to trial or the work that's going to go into going to trial, and people start allowing that to influence their decision about whether that case ought to settle. And so it is certainly important as you're moving toward trial that you consider the fact that the risk to the client of losing at trial, and that should always be one consideration, and whether or not to settle a case and when, and whether or not to take a case to trial and when. But one of the things that we cannot allow to happen is to allow the concern about the time it's going to take or concerns we have over our own ability to make a presentation at trial to allow to drive the decision on whether to settle that case. It should be based on the merits and the risks, not on our own internal confusion or concern.
Absolutely. Because ultimately, any sort of decision that's not strategically sound, it just is prejudicial to the client ultimately. And so, yeah, you want to make sure that you're considering everything you ought to consider when you're making those decisions. Next slide. I also just want to offer a reframe for anyone who is moving forward in developing their oral advocacy skills and thinking about sort of the next events that you have coming up. Typically, legal training conditions us to think in binary terms. So you either win the motion or you lose it, you get the admission or you don't. The favorable term is in the contract or it isn't. But really, that's not how practice works as much. There's so much gray area. And for oral advocacy events, there's so much key information, important benefit that you get from appearing and being present that you don't get if you say, submit to every tentative that's unfavorable. Um, but ultimately, you want to just go in thinking about what you can get out of the room besides, the obvious goal, which is, the win. So, can you get more information about the judge and what they think about you or your case? Can you get more information about what resonates with the court? Are you noticing that the judge is more favorable to you when you argue in a certain manner? Does the judge favor sort of short, snappy arguments, or is the judge more responsive to longer, more thorough arguments? You can assess how a witness performs under pressure. If you're taking a deposition, you may go to trial. That witness may be on the stand. So you may walk away with key information about how that witness presents when having to answer questions. You can understand more about the opposing party's goals, what they're looking to get out of this, whether that's a deal discussion or litigation. And once you gather all of that information, so much information follows and flows from that. Strategic decisions flow from that. And, if you're really present and focused, that can make you a really efficient advocate in that matter towards the end because you've compiled all of this key information that just only serves to make you better and make you more effective.
So I think in the interest of time, we're probably going to stop here. But I think it's a good start. And then if anybody has any questions, Chanel and I are happy to stick around longer than our so sort of dedicated hour. But I want to kind of wrap this up with this thought anyway, which is what goes along with what Chanel is saying here, which is ultimately, fundamentally, the goal in any oral argument, the goal in any step of a litigation is to get to the right result at the end of the case. And so the effective oral argument doesn't just focus on the obvious win for any particular hearing, but we should be using oral argument as another opportunity, just like any writing that we put forward to the court, to re-educate the court about our position and to prejudice the court, if you will, in favor of our clients by helping understand what our narrative is. In state court, particularly where courts in LA Superior, for instance, have over 1,000 cases on each of their dockets right now. You can't expect the court to remember the full details about your case. So it's important to understand in that argument, you need to remind the court why this is important to the bigger picture and not just what is the specific focus of this issue, but use every writing and every oral argument opportunity to remind the court why this matters in the big picture and why ultimately this should move in your favor. Does anybody have any questions for us following our comments today?
So it looks like we actually have so far two questions. Ralph Lemerandi is asking, AI seems relevant here. We're seeing a concern that quote unquote legal residency, the first years in litigation practice, is being usurped in many instances for first and second year hires by AI generation of depo questions, for example. Is this a concern? And if so, what is the prophylactic?
Yeah, it's actually a really good question and a really big concern. AI should never be used to replace the work that an attorney does in understanding a file and then their ultimate presentation. It is becoming, as it becomes increasingly more self-sufficient and adept as a tool, it would become more helpful to us in terms of identifying arguments, identifying issues, but it should only be used as a tool. We should never use that as an opportunity to replace our own institutional knowledge of a file, which has to be developed through your own work and your own memory, and also the analysis that goes into something. So while you can start a depo outline with using AI, or you can use that as a tool to help develop it or flesh it out as you go, I don't think that should ever change in terms of the fundamental work that needs to go into this because it is your unique insights and your unique institutional knowledge that's going to drive that analysis, not just what a computer spits out to you. So where I think it can become very effective is as a tool, but only as a tool, not as a replication for the hard work and dedication that needs to go into understanding a case strategically.
And I think also, this is going to be, hopefully not, but this is probably going to be another structural issue. If to the extent that firms are foregoing hiring first and second years or, decreasing the number of first or second years in a class to the extent that they rely on AI to make up for that productivity. I mean, it really is just setting a problem up 10 years down the line, because once again, we're putting attorneys into the field with just fewer and fewer opportunities to gain this type of experience. What is going to happen when all of us are the senior levels? So I really, I think it's more so just another structural issue if firms do go down that route. And to be honest, I'm not sure what will be the fix. Hopefully, we'll just have practitioners, if they disagree with what firms are doing and want to go set up their own environment where, attorneys are able to develop and, go that route. I'm not sure, but yeah, hopefully that's a structural issue that doesn't become too difficult to manage.
Well, ultimately, and I think you've hit on the right issue, ultimately, it's a matter of how we view our junior attorneys. Do we view our attorneys as people that we want to train and raise up to be the best lawyers they can be, or are we using them as just cogs in the machine to get to the result in the moment that we need? And if we take the macro view of the world, that our job as senior leadership in law firms should be to train these associates up to where they can effectively replace us someday, that's a longevity play, right? That's creating a legacy. Whereas if we're not making that investment now, there's going to be a long-term consequence to that. And I think that dovetails nicely with what you've been talking about today, Chanell, about oral argument. Like, we need to be focused in the manner in which we're preparing this, that we not only take these thoughts and ideas to heart, but we're willing to impart them on our junior attorneys and give them the opportunities that are available and identify those for them so we can help train them to be the next generation of this law firm.
Alrighty, Chris and Chanel, it looks like we have just one more question from Danny Sawaf. Regarding tone and parlance in ex parte or CMC, what do you advise?
Always be focused on the bigger picture. Be ready to talk about the bigger picture. Understanding that when you go in on, and you pick two examples, one being the CMC, the court may or may not ask you, how does this fit into the bigger picture? Or what are we dealing with on a going forward basis so I can know how to set these dates? And you have to be ready to talk about the overall case, and how where you see the case going so you can start road mapping and educating the judge with that in a respectful way. In ex partes, I think it's exactly the same thing. The judge needs to understand why this critical issue is not only an emergency, but why it needs to be decided now for the benefit of the long-term case. The only other thing I would add in terms of the way you handle ex partes, you should keep it very brief, and you understand you are borrowing the court's time that it does not have to give you. You are imposing on the court, if you will, an exception to their schedule. And so you need to keep it brief and to the point and very quickly help the judge understand why you need their attention right now.
Great. It looks like that's it for questions today. Thank you so much, Chris and Chanel, for an excellent presentation. And thank you so much to our audience.
Yes, thank you for joining us
Thank you
today.
so
It was a
much.
pleasure spending time with you.